Hi everyone, let's discuss about law of agency. Law of agency is an important law in Indian Contract Act 1872 which is contained in chapter 10 from section 182 to 238. So law of agency, it is deals with the agent principal relationship in a contractual agreement. So first let's understand about agent, principal and agency means. First one is agent. Agent is a person who is employed to do any act for another or who is represented. So agent is very important element in an agency relationship. Next one is principal. Principal is a person for whom such an act is done or who is so represented. Next term is agency. Agency, it is a contractual relationship which arises from the agent-principal relationship. So these are the terms which is important in agency, agent, principal and agency. Next, let's discuss about the rule of agency. First rule is that whatever a person can do personally, it can be done through an agent. But there are certain exceptions in case of this rule because it is not applicable in case of marriage because marriage is personal in character. Second rule is that he who does an act through an agent does it by himself. So the act of an agent is considered to be the act of the principal. These are the two important rules in agency. Next, let's discuss about the essentials of an agency. First one is, it is an agreement between the agent and principal. An agreement may be expressed agreement, implied agreement. Next one is, the principal should be a competent person. That is, in a contractual relationship between the agent and principal, the principal should be a soundful person. Next one is, agent need not to be competent. So, even a minor can become an agent. Next one is, there is no consideration is required in order to create an agency. Next one is creation of agency. That is, what are the ways through which we can create an agent-principal relationship. These are the types of agency, creation of agency. First one is agency by expressed agreement, agency by implied agreement and agency by the operation of law. Next one is agency by ratification. First one is agency by expressed agreement. When an agent-principal relation arises by word spoken or written, then we called it as agency. It is created by express agreement. So there are several types of express agreement. Next one is agency by implied agreement. Agency by implied agreement arises from the conduct of the person or it can be inferred from the circumstances. So there is no express or written or spoken agreement or relationship between the agent and the principal. An express implied agreement may be agency by estoppel, agency by holding out and agency by necessity. First one is agency by estoppel. Agency by estoppel, it arises when a principal knowingly permits another person to do an act for him. So the third person may believe that the person who is representing he has the authority to be an agent. Next one is agency by holding out. Agency by holding out arises when sometimes the positive or affirmative signal from the sign from the principal which make some other person to do an act for another person, then agency by estoppel arises. Next one is agency by necessity. Agency by necessity arises in some extraordinary circumstances when someone is acting urgently or immediately, who's not an agent but he is acting for another person, then agency by necessity arises. Next one is agency by operation of law, which can be explained by giving an example. In case of a company, we know that there are 3 stages of the formation of the company. First one is promotion, incorporation and commencement. And the promotional stage is carried out by the promoter. Here, the promoter is acting as an agent which is appointed by the operation of law. Next one is agency by ratification. Agency by ratification, let's discuss about what is ratification means. Ratification means that giving approval without any authority. So there are the rules which is related to ratification are The agent must be purport to act for a definite principle. Principle must be in existence at the time of the contract, and principal must have a contractual capacity both at the time of the contract and at the time of ratification. And ratification must be full knowledge of fact, and ratification must be made either within the fixed time or at a reasonable time, and ratification must not subject a third party to damages, and the act to be ratified must be lawful one. The act to be ratified must be within the principal authority, and ratification relates back to the date of the act of the agent, and ratification should be of whole transaction. Next one is, let's discuss about the classification of agent. The classification of agent, it is classified on the basis of on the basis of the extent of authority and on the basis of nature of work performed. First, on the basis of the extent of authority. Extent of authority, an agent is divided into special agent, general agent and universal agent. Special agent, such an agent is appointed to perform a particular task for a particular transaction. In case of a broker, if you want to sell a property, you may appoint another person who is a broker, and he is the person who deal with selling the property. Next one is general agent. General agent has the authority to do all the act which is in the ordinary course of business. That, for example, in case of a manager who is appointed in order to carry out the business transactions in the organization. Next one is universal agent. Universal agent has all the right, or he has the unlimited authority to bind his principle. Example, in case of a person who is living abroad, who is leaving India, and he is making his son as an agent to carry out all the activities which is related to him, then it is known as universal agent. Next one is, on the basis of the nature of work performed, it can be classified into mercantile agent and non-mercantile agent. Or mercantile or commercial agent is an agent appointed for the mercantile or business affairs of the business. So the business activities, it may be consist of trading activity or commercial activity. So when a person is representing in order to carry out the commercial activities, then mercantile agent arises. Next one is non-mercantile agent. Non-mercantile agent is an agent who is appointed in dealing with unrelated items and unrelated activities in a business, is considered as a non-mercantile agent. In case of insurance agents, solicitor, clearing and forwarding agent is also considered as non-mercantile agent. And mercantile agent is classified into different ways. So let's discuss about the mercantile agent. First one is factor. The factor is a mercantile agent who is appointed, and he has the right to possess the good, and he possesses the good in order to sell it in a future date. Next one is broker. Broker, we know that a broker is employed in order to buy or sell out goods or services on behalf of another person. Next one is commission agent. Commission agent is an agent whose act on behalf of another person for a consideration which is called commission. So next one is auctioneer. An auctioneer is an agent who is appointed by the seller in order to sell his asset in a public auction, in a public forum. So this is auctioneer. Next type of agent is declarer agent. Declarer agent is also a mercantile agent, and mercantile agent who is dealing with he is actually an agent. Extra, he is giving a guarantee to perform the act by the third person. Next one is banker. Sometimes our payment, like our electricity bill, our phone payments, or any other payments, charges, or in case of any bill or draft which is carried out by the banker. So these are the different types of agent. So these are all related to agency. Thank you, everyone.